So this is when bail can be denied. You're a twice convicted felon accused of a non-capital felony. And the important part here is that the second felony conviction takes place after the first. What I mean by that is if you get in some trouble and in that instant you've been charged with 24 felonies, those are not 24 separate convictions. That will be considered one conviction. So through the media, on shows like Breaking Bond, I've seen them tell the public that, oh, this person has, multiple felonies, they should not be out on bond. What they fail to inform the public of, and I'm not sure if that's malice or ignorance, they fail to inform the public that those felonies were all in the same incident. Therefore, that exception doesn't apply to that particular defendant. No matter how much they bang their fists on their desks and pull their hair and say how corrupt the judges are. Next exception. If you've been indicted on a felony, you're out on bail, and then face another non-capital felony, your bail can be denied. So translation, you were indicted for a felony, you're out on bond, and you're charged with another felony. Your bail can be denied. And as with all of these, the district attorney still has to schedule a hearing and present all of the evidence to the judge to say, hey, this is why we need to deny bail, revoke bail, whatever the case may be. And at that time, then the judge can deny bail or revoke bail. Not before that, not because you've seen a news show that has told you this, not because your friend told you or a cop told you. That evidence in those situations have to be presented to the judge in a hearing. Next exception, a former felon accused of using or displaying a deadly weapon during a new felony. So translation, so you've been convicted of a felony, you've got out, you're not on parole, anything like that. The cops catch you with a deadly weapon and you're in the commission of a felony. Your bail can be denied. Next exception, you're under state supervision and you've been charged with a violent or sexual offense. You can be denied bail. Translation, you're on parole, probation, or maybe community supervision. And if you get charged with a violent or a sexual offense, your bail can be denied. So example, if you're out on probation for a DWI and then you're charged with aggravated robbery, you may be denied bail. Next exception, you violated a protection order in a family violence case. If you were arrested for family violence and you had a protective order in place, and you violate that, you can be denied bail or it can be revoked. So an example is you were arrested for family violence and you're out on bail and you violate that order by maybe showing up to their house. That judge can deny bail while the case is pending. Now, with that said, there are still limits on this denial of bail if you fall into one of these exceptions. So even with all these exceptions and these denials of bail, there are still limits on how long someone can be denied bail. And I think that part is probably very frustrating for people, but that is the reality of the law. And like I've said before, the DA has to present in court the reason for the request to deny. TikTok can't tell the judge, Channel 11 News can't tell the judge, a victim can't walk up to a judge and say, hey, this happened to me, please revoke their bail or please deny this person bail. That's not how it works. The law states that this request by the state's attorney, the law also states that this request must be done within 7 days of that person being booked. Now, that doesn't mean that if the DA doesn't get new information that they don't have the opportunity to again request a hearing and request that bail be denied. Now let's say the district attorney has, done the process. They said, hey, this person is supposed to be denied bail based on XYZ. They've gone to court, they presented the information to the judge, and the judge is like, okay, got it. Bail is denied or bail is revoked. If trial doesn't happen within 60 days, bail must be restored. And yes, you heard me right. Even if they meet these parameters of being denied bail, the state still has to take their case to trial within 60 days. Otherwise, bail must be restored. So this is where I tell you about how understaffed and under-resourced our court systems are around the nation, no matter if you're in a rural area or in an urban area, Republican or Democrat, whatever. Court reporters are in low supply in general, and it's very, very hard for counties to get assistant district attorneys. Those are the people that are trying these cases because the money's better at a private firm, period, the end. A private firm has better resources, better staffing. So if you want to know why everything takes so long, you should look to your local leaders and ask them why. And also, you should understand that that is going to mean an increase in money somewhere.